Alex here with part 93 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0. If you haven't seen it yet, that is the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I always glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one large example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We're going into my opposition to my ex's attorney's motion to quash my subpoena. My mindset at the time was dismayed. I am hesitant to say that because I'm actually more dismayed now than I was back then. I can't say that it didn't come off as a complete shocker. I feel like at that point in time, I started to pretty much expect my ex and her attorney to do things that reflected the win-at-all-cost mentality. I would have been more surprised if she caved or if she agreed. Now, in hindsight, looking back, to me, it seems clear that what my ex's attorney tried to do in my case, I don't think she would have tried to do with another attorney. And having reviewed her motion, which was very short and contained hardly any authority at all, I imagine she didn't even think that that was going to work. And we're going to get more into the outcome when we actually get to that point, because this wasn't a clear outcome at the end of this road. It's kind of murky, and I have a lot of thoughts and a lot of things that I want to say. I don't think that there is much that I could have done to alter the outcome, and I blame that mostly on the judge, or more specifically, his worldview and his mentality and his approach to high conflict child custody. And I don't want to get too philosophical because we need to get into the actual documents. And I keep having to tell myself that as we go through the series, there's better opportunities to talk about this stuff. Like when he actually enters into his order, that might be the better video to talk about some of the stuff that I want to talk about. So let's go ahead and take a look at what I have filed. Here we have my opposition to my ex's attorney's motion. And I lead off with the standard introductory paragraph identifying myself to the court as the petitioner, indicating that I have no attorney, I am appearing in proper person, and stating clearly that I am filing an opposition, and I identify the title of the document that I am opposing and the date that it was filed. And wait a minute. I don't actually mention the date that it was filed. So guys, that's the best practice advice for me, is when you identify the document that you are opposing or replying to try and put down the date that it was filed by your opponent so that the court can 100% for sure pinpoint that document. Usually they can figure it out on their own, but if you can do that one extra little thing for them, I think that that's very helpful. And I do have a date here, but what I am doing is apparently identifying the motion to modify child custody, which I guess makes sense because this motion practice here isn't really in a bubble. It's connected to the main thing that I'm trying to do, which is to modify custody. Next paragraph, we have factual background, or next section, which is the factual background. We lead off with what is probably a standard introductory factual background. Let's take a look here. March 3rd, 2008, we were in the midst of a separation. My ex told me she was going to pick up our minor child, and she said okay, so I'm going to omit some of these statements, guys, because it'll trigger a yellow flag in my YouTube video. As I'm explaining what's going on, make sure you read along in the document. Sensitive phrases and topics upset YouTube advertisers, and it's not just the advertising revenue that's impacted, it impacts the video's release. So not enough people get notified of this video when it gets yellow flagged. And again, yellow flagging is not that big of a deal. Red flagging is bad, but when a video is yellow flagged, it's I think it unfortunately limits, I think by at least 50% who they distribute the video to. And I try to get these videos to as many people as possible. So certain topics I try to avoid. And I think some of you at this point have noticed that I do that, but that's the reason why I do it, because it's very frustrating for me to put all this work into a video for then YouTube to yellow flag it and release it to a very specific, or more so a very limited audience. I'm trying to get as many people to see these videos as possible. Many people in this country end up going through child custody cases. This is not a niche thing that happens to Americans. This is something that happens to more than half Americans. So anyway, moving on. My ex sent me these messages, and I contacted the Reno Police Department. Several police officers arrived, and wow, this is a pretty long paragraph. I am reciting a portion of the police report here. I'm not going to go into details because in part, I believe it was part 2 or 3 of the My Docket series, I already analyzed this police report very thoroughly. So if you want to see my analysis on the report, definitely take a look at parts. I think it's part 2, it might be part 3 of the My Docket series. She was remanded into the custody of West Hills Mental Institute, where she remained for 3 days, which is pretty standard. My understanding is anyway that it's pretty standard. And the next paragraph, I assert that I sued my ex for custody and visitation, seeking joint physical custody. Next paragraph, the court awarded joint physical and joint legal custody. Next paragraph, I filed a motion to modify custody, and this is where we're at basically right now. And the reasons that gave me concern regard my ex's mental health, specifically the affidavit of my son's kindergarten teacher, which states, and I'm just going to go ahead and paraphrase here, but that my ex is deliberately trying to sabotage our son's education. Next assertion here is that on October 25th, 2012, we scheduled a hearing on the motion to modify. On October 29th, I had 4 subpoenas issued, including 4 subpoenas, and separately 3 subpoenas duces tecum. On the same date, I served my ex with copies of these subpoenas through and by her attorney. I didn't serve her directly. Next, we have the assertion that 6 of the 7 subpoenas were served by an individual. And then after that, we have that my ex filed a motion to quash the subpoena, duces tecum, instructing the hospital to produce. Okay, yeah, this is where we're at. So she's trying to block the release of these records. Legal analysis. 2, our son's teacher, her conduct is so beyond the realm of understanding that she felt our son's best interest would be served by disclosing perceptions to me. Understandably, certain acts of parental misconduct exist in our society, and they can stem from any number of underlying issues. But when a parent intentionally tries to take active steps to engineer the failure of their own child at school, we need to be willing to explore every possible underlying issue. And I shouldn't even be having to do this much work because it's in the statute. It's like I have to do this tremendous amount of work to get my judge to just pay attention, which I shouldn't have to do because the Nevada Revised Statute specifically states that the mental health of the parents is relevant. But yet here I am trying to get this guy to wake up and take a look at something. It's really frustrating because now, I mean, back then I probably thought this was normal, that this is just how all the judges were. But now, with the benefit of hindsight, I'm like, I don't think a lot of judges would have made me have to do all this. I think a lot of judges would have wanted to see those records. And I know for sure that the legislature wants those records to be reviewed. Okay. Next, we have pursuant to the law in determining custody of minor children. The sole consideration is the best interest of the child. Pursuant to another statute, in determining the best interest of the child, the court shall consider and set forth its specific findings concerning, among other things, quote, the mental and physical health of the parents. It's like to try and get this through the judge's thick skull. It shouldn't be this hard, and he makes it so hard. And it's a different version of me now than back then, because again, back then I just assumed that the judges were the law. I didn't understand this concept that the judges are supervised by both the legislative branch and the Supreme Court. To me, the judge was everything. Now, here I am in 2020, and I'm like, what is he thinking? Anyway, we'll continue on. Statutes reinforced by a bunch of case law. And we'll go into the next section here. Psychologist patient privilege is controlling. This is what I was talking about in the previous video. It's not confidentiality that controls, it's privilege that controls. Pursuant to Nevada Revised Statute 49.015 subsection 1D, and we go into no person has a privilege to prevent another from being a witness or disclosing any matter or producing any object or writing. And this is going to go into more details in what you'll see as we go down further here. As my ex is confronted by discovery, the court should, in accordance with the rules of civil procedure, construe her attempt to quash under psychologist patient privilege, which is, so basically I'm trying to say that my ex's efforts to try and quash under this general principle of confidentiality is wrong, and that what she should be trying to do is try and quash under psychologist patient privilege. The reason my ex's attorney doesn't want to do that is because it's going to lead the judge to the law that is going to ruin her argument. It's going to doom her to loss. So she's trying to keep the judge away from the statutes that discuss psychologist patient privilege, and she's trying to confuse him with different statutes by conflating those statutes that are wrong with the statute that's actually correct, or at least the principles behind it. So my ex has a right to invoke this privilege. However, there are exceptions to the rule. And here we have Nevada Revised Statute 49.213. There is no privilege pursuant to the law if disclosure is otherwise required by state or federal law. And then I cite subsection 8, which states, for communications relevant to an issue in a proceeding relating to the abuse or neglect of a person with a disability or a person who is legally incompetent. So that's where we are, a child. A child who may be abused or neglected. I'm bringing that issue before the court. That is an exception to this specific type of privilege. I have cited statutory authority that requires the court to consider my ex's mental health when determining custody, unless emancipated. And I'm not even asking to win based off of it. I'm just asking the court to consider it. I'm just saying, please take a look at this. And he just won't do it. Anyway, moving on. Unless emancipated, a minor child is considered legally incompetent. And I cite another statute that indicates as such. Pursuant to the law, abuse or neglect of a child means neglectful treatment or maltreatment as set forth. And then there's another law that controls that. I go ahead and I go into the details as to how the statute works. Negligent treatment or maltreatment of a child occurs if a child has been abandoned, is without proper care, control, and supervision, or lacks the subsistence, education, in bold, shelter, medical care, or other care necessary for the well-being of the child, quote, because of the faults or habits of the person responsible for the welfare of the child, or the neglect or refusal of the person to provide them when able to do so. Again, guys, I feel like most attorneys wouldn't need you to go this far. I think most attorneys would tell their clients, this is a custody case, those are your kids, it's relevant, turn over the docs. But this is not most attorneys, this is not most judges, and my ex certainly is not most exes. Moving on. Therefore, my ex's alleged conduct is abuse and neglect as defined by law, and her privilege does not apply in the instant case. The Nevada Supreme Court has not yet published a case wherein it is explicitly stated that in child custody matters the best interest of the child standard overrules appearance of psychologist patient privilege, but I have located persuasive authority, and persuasive authority, guys, is authority that comes from another jurisdiction. So we have mandatory authority, which is authority that comes from our jurisdiction in Nevada, and then we have persuasive authority, which is any other jurisdiction, so it could be any other state or it could be federal. The Alabama psychotherapist patient privilege, however, is subject to certain judicially created exceptions. This court has recognized an exception to the privilege where, in a child custody matter, the mental state of one of the parents is at issue, and a proper resolution of child custody requires disclosure or otherwise privileged psychiatric records. You don't even have to make this a legal issue. I think if you went out and asked most people in society, do you think a parent should be able to hide their psychiatric and psychological problems in a child custody dispute? I think 99% of people would say, what? No, that makes no sense at all. Again, this is not the ordinary case. It's a high conflict child custody case. We have two more citations here. This first one states that the psychologist patient privilege also has been held to be pierced in a case requiring the court to conduct a best interest of the child analysis. Next assertion, in implementing the best interest of the child standard, Courts rely heavily on the expertise of psychologists and other mental health professionals. C, and then they go into all of these citations as to why it's relevant and why you cannot hide this information from the court. Moving on. Our son's best interests are prevailing. His best interests are served by requiring that the mental health records be disclosed and scrutinized. I feel like a lot of the stuff that happened in this case could have been prevented if the judge just did his job. We elect them to do a certain job, and some judges, they invent this idea in their head that their job is something else. And it's like, no, we didn't elect you to be a therapist. We didn't elect you to be a psychologist. And we elected you to be a judge and adjudicate issues. That's what you're there for. That's your job. If we wanted a therapist to preside over these cases, we would fire all of you and replace you with therapists. You know, it's like, do your job. It's tough for me now looking back at this because this is egregious, like what I'm seeing here. And this is not, it should not have taken this much work to get the court to do its job. It shouldn't have taken that. It took a tremendous amount of effort just to get the court to do its job. And it's really, at this point in time, since I'm already done with my case and everything's over, it's really infuriating. Next section here. Petitioner stipulates to a protective order. The court has the authority to enter a protective order. Okay, so this is me trying to say, if you want to protect my ex's like privacy, you can enter a protective order not allowing me to release these records to other people. And I'm trying to tell the court, I will consent to this. It doesn't matter anyway. In the end, it doesn't matter. Conclusion, my ex's motion to quash should be denied. Declaration, which is my standard, swearing under penalty of perjury that everything that has been alleged in this document, everything factual that has been alleged, is under penalty of perjury and under oath. Next we have Rule 5 Certificate of Service, indicating that this opposition was personally served upon my ex's attorney. We have a standard motion opposition notice, and according to these check marks, I do not have to pay a filing fee. List of exhibits, police report. So I've already gone through this police report, and as my standard protocol, I'm going to stop here at this point. Let you guys know that if you would like to, you can go down into the description below, click on the link, download the document for yourself, read it, and if you have any questions, you can go ahead and post it down in the comments below. Keep in mind, any document that I skip over, I have already gone through it. So if you go to my Docket series, I think it's part 2 or part 3, you can actually go through this specific police report and you'll get my analysis on the police report at that time in full. Going into the aftermath, I think, well, first off, I filed one document, so I didn't incur, well, it was a free filing, so I didn't incur anything in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably spent very little time in reviewing this document. I think most of the time that she would have spent will come in the filing of her reply, which should be the next video. So I think most of the time and effort that is going to get computed against her attorney fees is going to be in that specific video. So I think at this point in time, it's reasonable to say I'm here between 15 and 30 minutes. In this case, I think I'm gonna err on 30 minutes. 30 minutes for review of the documentation and maybe to briefly communicate with my ex. That's going to come to, at the rate of $250 an hour, $125 in attorney fees for my ex. If you have any questions, as with my previous videos, feel free to post something down in the comments below, and I will see you guys next time.